Please be seated. We'll hear argument in 23-644, Kensington Title-Nev versus Texas Department of State Health Services.
May it please the court, Mr. Lampe and Mr. Nord will present argument for petitioner. Petitioner has reserved 5 minutes for rebuttal. Mr. Lampe will open with the first 10 minutes. Mr. Nord will present the rebuttal.
May it please the court. This case has significant ramifications for how radioactive material is controlled in the state of Texas. If the court sides with dishes in this case, then licensed users of radioactive material will be permitted to abandon RAM, leaving innocent landowners to clean up the mess. Kensington Title-Nev LLC has never held or sought a license from dishes to do anything related to radioactive material. As background, and there's a timeline in our presentation, tab D, page 25, which may be helpful. Kensington foreclosed on a deed of trust in 2018 when the real property was owned by 2 other entities. Kensington's foreclosure deed did not include any liens on any of the personal property located on the real property, to include the subject RAM. Kensington notified Dishes that when it took possession of the real property, it wanted Dishes to take possession of the RAM. The court will note that every party and named actor in this suit has a better claim to ownership of the RAM than Kensington, which has never claimed ownership of the RAM or attempted to use it. Prior to the foreclosure and the events of this dispute, Dishes obtained a final order to decommission against another entity known as USR, who is also the owner of the RAM and who had sought a license from Dishes. The court should know that there's another entity that does have a license, Trace Life Sciences, who as recently as last February received a letter from Dishes regarding the status of the RAM on the property. These other parties are either licensees of Dishes or legal users. In 2019, the taxing entities in Denton added Kensington and its individual members to a tax collection lawsuit that had been pending for years regarding separate tax accounts for the real property and for the radioactive business personal property. In October of 2020, Dishes sent Kensington a notice of violation claiming a violation of the rule, which in this case was 25 TAC 289.252A2. The following...
So your suit against Dishes preceded the administrative proceedings. When you added them to the tax suit was before the administrative proceedings began.
Yes, and then they, following that is when, the February is when Dishes filed the request of docket with SOA. Kensington never did that.
So in the tax suit that you mentioned, when this first came up and Dishes was added as a party to the tax suit, that's when you brought up section 2001.038 and sought the declaration.
Yes, and then we amended once it was moved down to Austin,
right,
to further clarify the how versus whether, which is the big.
So that came first.
Yes, sir.
And does that shed any, is that the frame in which we should look at the redressability argument that the state raises? Because the state says, well, your request for a declaration under 2001.038 would not redress your injury from the ALJ's ruling and the administrative process. But if the 2001.038 suit came first, why do we even look at the administrative process to see whether it's fully redressable or not?
Well, we shouldn't even have to be in the administrative proceeding. We were forced into the SOA proceeding, and while we're in there, we fought to get out by filing a plea to the jurisdiction and the motion for summary disposition, both of which were denied. So we were forced, Kensington was literally forced into that position, but we did not file the request to docket that case. That was a reactionary thing from Dishes that put us into that instance while this declaratory judgment matter was going on. It should be noted that the Denton taxing entities hold judgment liens on the radioactive material, something back at the time is $773,000 on the radioactive material.
And as I understand it, they told your client basically, if you keep removing it, we're going to sue you.
Well, they didn't. They sued them. There was a discussion with Mark Burrows, may he rest in peace, who is the attorney for I believe the county of Denton, about what was going to happen, and that's when Kensington was added to this tax lawsuit, and so were the individual members in their individual capacity.
So that's why your client stopped the decommissioning, was because they got sued by the tax lien holder.
Right, because their choice was, let's remove this, okay, well, what happens if we remove this, and now we're stuck with this giant bill by these taxing authorities.
So you've got one government entity on one side telling you got to do this, and other government entities telling you can't.
Precisely. And we didn't purchase this. It was literally abandoned by USR on the property. We're stuck with this giant masses of radioactive material. When I say giant masses, they're large things. 18-wheelers were required to be moved. Again,
Where is the decommissioning process right now by anyone? And
well, that's a great question. Nothing's happening. Your Honor.
Second one, just sort of where we are right now is, I know the ALJ imposed a administrative penalty, and I understood that was part of a separate proceeding, and I wondered what the status was on that.
Well, we haven't paid it, and there's been no enforcement against that. I believe since all of this has been going on, I think there was some threatened enforcement by Dishes to continue, and I believe I emailed counsel for Dishes while it was saying, hey, let's fight about one thing at a time. We had this appeal from Travis County and the Third Court of Appeals. So the decommissioning, nothing's happening. The radioactive material is locked up behind key on the property.
You don't have a key, right?
There's a caretaker there that has access, but no one's allowed to walk in there without Dishes' permission.
Why did you take possession when that was the case?
So first of all, we never took possession of the radioactive material.
Well, no, but.
Right, so going back, how, you may ask, well, why would you buy property with radioactive material? We didn't buy property with radioactive material. How this came to be was a settlement between Newview Life Sciences and Newview Pharmaceuticals, or Molecular, I forget the name, two entities with Kensington. And so as part of that, there was this deed. And there were no payments ever made on this amount that was owed as part of the settlement agreement. Therefore, Kensington foreclosed to try to get something. However, in the meantime, USR is leasing the property and has this giant radioactive material things here that we have to deal with. So none of the subject deed in here doesn't list any kind of lien on the personal property. So it was just there. And then, even though USR had been ordered to decommission the site, there's a final order from SOA to decommission, nothing's happened. There's been apparently no enforcement by Dishes to get USR to come and get their stuff off of the property. So that's why we have this issue, is that's why we're saying we're not a licensee. Well, we aren't a licensee. But radioactive material has literally been abandoned on our property. What does a landowner do when radioactive material is abandoned? In this case, if Dishes prevails, it turns them into an accidental licensee, which is subject to the rule here in this case.
If you obtained ownership of real property and there were treasure chests of gold that had been abandoned, would you take the position that that's not your gold?
Well, radioactive material is definitely not, I don't think that's a really good analogy. Treasure chests of gold don't kill you slowly through cancer with radioactive material.
I know you would like to not own the one, and maybe you would like to own the other, but the point I got from Justice Lehrman's question is you're the owner of this. Now it's been abandoned.
Well, we're the owner of the real property. We've never said that we're the owner of this business personal property.
Wouldn't that be something that's factored into the price? I know that the way you got it was different, but if this were something that were just bought and sold on the open market, it would be something where you'd look at it and say, all right, well, there's going to be risks, costs, whether the prior people that had this are going to do their job or not. Maybe it'll be a Superfund site, and so the price that you would pay for this real property would dramatically decrease, right?
And we don't have that. And maybe if we were going to buy it, if you were going to buy that facility now with the tunnel, I believe this is all left over from the colliding superconductor stuff that happened when I was a child, right? And so if you were to rebuild that site, it would be $35 million. I'm picking a number. Large numbers to go in actually this kind of facility. I don't know if that specifically answers your question.
Well, to focus on really the legal question that I think is motivating us, we have 2001.038, and we have to decide whether or not all of the things that we're talking about are properly addressed using that vehicle, or if not. What do you think 2001.038 means when it talks about?
I think it gives Kensington the right to come and say, this rule does not apply to us. We've never applied to have a license. The radioactive material was abandoned on our property.
So what makes it different from other circumstances? Is it that you're bringing forth certain factual circumstances that you say, look, these are unchallenged, that there's no need for a fact finder to determine anything about whether there's nuclear waste here or anything like that? We're just saying, given the state of the world, does this rule apply to people in our situation, or is that what makes this an appropriate?
Right, this is whether at all these rules, DISH's rules apply to our client in this situation, and those similarly situated, because this could be any landowner. This could be anybody let's say any licensed user of radioactive material goes down the street and puts a box full of RAM somewhere, and now the owner of the property is left standing and saying, what do I do with this? Do I clean it up? I can't, because the rules say that if I dispose of it, if I transfer it, I have to have a license for that. So it's a catch-22 position. We can't do anything. So,
If the dispute were about what kind of material it was instead, would 2001.038
as
be
far as
available?
if it was not radioactive material, then DISH's wouldn't be involved.
Or there's a dispute about whether it might be, we don't know for sure if it is.
There's no dispute of whether or not.
I know,
yeah.
but my question is, if that were the circumstance here, would 2001.038 be an available vehicle for you to try to get some relief against the government?
Well, I think in this situation, if we're not dealing with RAM, but if we want to look at whether a rule applies, then we have to say, well, we're not arguing about their this is the whole case law that's about. The cases argue about how the particular agency is applying those rules. We're saying you don't get to apply them because we're not part of this game.
Any other questions? Thank you, counsel. Mr. Dart, we'll hear from you.
Good morning, may it please the court. Let me answer a couple of questions that popped up already. The redressability question, and I've summarized all of the cases that I thought were interesting in the way that I wanted to summarize them at the end of the presentation. I find it handy to be able to figure out which things are on the fly. The Heckman case was about some prisoners that were seeking remedy because they wanted to have a court-appointed attorney. And the redressability issue, the quote was, each form of remedy would have remedied in some way Heckman's alleged injury, therefore each independently satisfied the redressability requirement.
I have a different question for you about how far we can, how many issues are in front of us and how much of this case we can dispose of at this point. So if we agree with you that that there is redressability here, and we agree with your understanding of 2001.038 that this is a whether question of whether the rule applies at all, can we then get to the merits and say that you did not possess the personal property, or do we have to send that back?
I wish you could, but I think the proper right answer is all we're doing here, this is a pleaded jurisdiction appeal, right? So all you can do is reverse and remand. That's my ask at the end of this, is reverse and remand. Now, there may be some rule that allows the court, a high court, to make a decision and say that, but all we're here to do is determine whether or not we've pled a proper challenge. So then it goes back to the trial court to determine whether or not the challenge is valid. But I want to make very clear here, we gave this to the presentation to little black clips so you could do this very easily. You can't do it because now it's all stapled. But if you look at the actual declaration we requested, which is on page 11 of your presentation, at the very bottom, it's under tab B. At page 11 is our actual declaration. And you'll see the words that we use, and you'll see that we never say that this case should be decided or declared based on that we don't possess it. We're challenging the application of the rule, not the specifics. So page 11, paragraphs 20 and 21, one of our requests is DISHs may not attempt to force owners of real property to accept liability for radioactive materials abandoned on their property, or assert that owners are possessors of radioactive materials when such materials are so abandoned. That is not a request to find that we haven't possessed it. That's a request to say that rules can't be applied to people when radioactive materials are just abandoned there. And paragraph 21 is what Mr. Olympia said earlier. DISHs may not create accidental licensees. Again, it is not about whether or not we possess it.
Why couldn't it be, though? It seems like that would be within the scope of this statute to say you're not a possessor and therefore the rule doesn't apply to us. And so I'm not sure why you're running away from that.
Because that is an application of the rule. And by the way.
Well, I'm not sure it is, because it seems like, and that's why the third court's precedent is so confusing. This application applicability thing is very hard to understand. But it seems like a clearer way to articulate it is, if the question is whether the rule applies or not to a given set of facts, that's within the statute. And then if the question is, what's the outcome when you apply the rule to a given set of facts, that's maybe not within the statute, or at least we would have to have some more discussion about whether that's within the statute. But your position seems to be this falls within the first category of whether it applies at all to these facts, and under those facts, you're just an owner of the real property. You're not a possessor. You're not anything else.
Yeah, I have a thought experiment, and see if I can do it in 1 minute. Let's say you were stopped on the way home by an officer of the law, and the officer said, you are not wearing a proper helmet, so I'm going to give you a ticket for not wearing your helmet. And you could defend by saying, well, I've got this World War II helmet from World War II that I like to wear. It should suffice. Or you could say, I'm over 21, so I don't, and I've got the insurance, so I don't have to wear a helmet.
Right.
Or you could say, I'm in a car. I'm in a car. That's a qualitatively different defense to say, those rules don't apply to me. I'm in a car.
But the rules also wouldn't apply to you if you were over 21.
That's true.
And, they're the same kind of defense. It's just two different reasons for that, why they wouldn't apply.
I would suggest that the High Court adopt applicability versus methodology of application, instead of using two words that are synonyms in 99% of the time.
But it doesn't really matter, does it?
But it's hard to understand, right? And so the issue is, or the party, and all the cases are talking about this. The EATX talks about this as on one side, the LMV is talking about another. If I'm talking about applying a rule to determine how many beds are in a nursing home, and the nursing home says, well, you did it wrong. Well, the rule applies.
Sure.
Okay? We're not arguing about that.
It's just a question of what's the proper outcome.
Right. And so, but if we're talking about EATX, where TABC says we've invented this new rule, you just don't get to go around inventing new rules, even if we're innocent. Even if we're innocent, it's a grander, bigger challenge. All we're asking to do is for this court to recognize we have made that challenge and send us back down to the trial court. So now I think I'm out of time. We'll see you in the
Any other question? Any other questions? Thank you, Mr. Nord. We'll hear from the state.
May it please the court, Ms. Jackson will present argument for the respondent.
May it please the court. I'll pick up where we left off on the legal standard. Kensington's rule applicability challenge under section 2001.038 is invalid for at least two reasons. First, section 2001.038 does not confer jurisdiction to determine how a rule should be applied. That's what we've just been discussing. Kensington is not asking whether the rule is relevant or capable of being applied to a broad factual situation.
It seems like that's exactly what it's asking.
What Kensington is actually asking is it's seeking to compel agency action to its specific factual instance for a particular outcome. What
action are they seeking to compel?
Well, if we look at
They want you to leave them alone.
Well, they're actually seeking a little bit further than that, Justice Busby. They are, if we look at existing case law that controls on this point from the Third Circuit, or from the Third Court.
Well, that doesn't control.
Well, of course, but that is what we have to look to as relevant authorities. So if you look at the LMV case, for instance, there the memory facility owner was seeking to have the government license 30 rooms as double occupancy so that they could put 2 beds in each of those rooms. That was a specific government action that the owner was seeking to compel. Here, Kensington is likewise seeking to have the department assign decommission responsibilities to someone else. Specifically, they're looking to once licensee, USR. And that takes us to another case.
Well, that's up to you whether you pursue them or not. It seems like you're obligated to under the statute.
Of course, but that is not, that's not within the scope of an applicability challenge.
Okay, well, fine. So I'm not sure they're asking us to mandate that you pursue somebody else instead, but assuming they are, we can carve that out.
Sure.
But why isn't it, I don't understand why this is not a case where they're saying if they're just possessors of the real property, so this statute doesn't apply to them. Because they don't possess, they don't own the personal property. It's not a fixture, so it doesn't come with the land. It's movable personal property, and they don't possess it or they don't own it. So the rule doesn't. That's a whether question, it seems to me.
Well, it does go to the particular outcome that they're seeking in this case. And once again, we look to the relevant authority that we have on this point, the LMV case. They were seeking a particular outcome to get those 30 rooms licensed as double occupancy rooms. In D. Houston, the same thing is happening. They were asking the agency to apply the rule to someone else. And again, that's exactly what Kensington has done in this case. So to the extent we have relevant authority on point, Kensington falls clearly on the side of the application cases and not in the applicability camp.
Well, it seems like the LMV case was about how many beds you could have in a room. Nobody disputed that the rule applied to them. It was just how many beds would you be licensed for, 1 or 2 in particular square footages. That seems quite different from saying you can't fine us because the rule doesn't apply to us at all.
Well, again, I think that is how they have styled their challenge.
But isn't that really what it is?
Not if it's seeking a particular outcome or it's asking.
The particular outcome is don't fine us.
The particular outcome is also apply the rule only to another entity, USR, decommission the property yourself, remove any responsibility.
Well, you have a duty to do that by statute.
But part of the declaration is seeking that particular outcome, and it's seeking to control government action, which is just not part of an applicability challenge.
Is it possible that the statute waives immunity for a portion of what they're seeking, of the declaratory relief they're seeking, but not the rest?
I don't believe that's available in this case. I think the closest analog we would have is the D. Houston case where
I'm sorry, you got to speak up just a tad.
I think the closest analog that we do have is the D. Houston case, and there the petitioner specifically asked for the court to apply applicability standard, at least in part, to some of the declarations that they were seeking. Here, Kensington has not made that ask of the court, so I think that is not how the case is being litigated, frankly.
I mean, if their petition specifically prayed in the prayer at the end for a declaratory judgment that A, this rule does not apply to us, and B, this rule requires dishes to go after whichever other entity, is it not possible to say, well, look, it waives immunity for A, but it doesn't waive immunity for B?
I think it depends how that declaration would be framed, of course. Here,
And if that's so, they would have the ability to replead, right?
That's correct. Kensington has asked that the rule does not apply to them because they are a licensee. I think that is a nonsensical approach to this rule. It would fall into the category of LMV and D. Houston, where the courts in those cases indicated that it can't seriously be questioned whether or not the rule applies, at least in some way.
Well, that's merits. I mean, if the argument for why the rule doesn't apply is nonsensical and can't seriously be argued, then 91A applies and you get out because there's just no claim asserted. But the fact that they're seeking a declaration that the rule does not apply here seems to fit right within 038A.
I think it depends what they're seeking, and they have not actually sought that the rule doesn't apply to a broad factual situation. What they have sought is that the rule does not apply to them for specific factual.
The second half of 038A sort of requires that. I mean, you can't just seek a declaration that some rule doesn't apply. You can only seek a declaration that the rule doesn't apply if you allege that the rule threatens, interferes with, or impairs a legal right that you have. I mean, it has to be connected to them. in the declaration of inapplicability that they're seeking, doesn't it?
It does have to be connected, of course, under the plain terms of the APA, but again, we go back to whether or not they're asking if they are trying to seek to control government action through their declaration.
The problem with that is it seems like that is true of any party involved in any kind of dispute like this. Every party that opposes what the agency is doing is seeking a particular outcome. So that doesn't help me understand the difference between whether they should be able to proceed or not.
I would actually disagree with you on that one, Justice Huddle. If we look to the accident fund insurance case, there was a successful applicability challenge, and what was being sought was just a broad declaration of whether or not individuals who were doing private job seeking outside the context of their insurance carrier would be subject to the rule. The insurance carriers were asking so that they would know whether or not individuals who were part of their network were going to be subject to this rule. It was not specific to any one individual. There were no identified injured workers that were currently doing search.
So
work searches.
how should Kensington have framed its request for relief to satisfy the statute in your view? Would it be enough to substitute landowners versus personal property owners, or just stranded personal property as opposed to the specifics of what occurred here, or how would you frame an appropriate request under the statute, under the 038?
Well, it certainly can't be how they attempted to frame it at first, which was just that it doesn't apply to
Right, I've heard a lot about
non-licensees.
what it can't be. What should it be to satisfy DISH's view of the statute?
I think if the court were looking for a successful applicability challenge here, Kensington might have sought a declaration whether or not the rule applies to a non-licensee who does not possess or own or otherwise acquire the property.
Okay.
Because that seems to be the nub of their factual issue, whether or not they possess or own that.
Okay, and how is that different from the request they made, other than using proper nouns for these roles that we're seeking clarification for?
Well, the request that they did submit is, again, much more in line with the requests that were made in LMV and D. Houston. They're very detailed. They also point out to other specific people that they want the rule to apply to. They don't indicate why the rule doesn't apply to them, but they're specifically saying it shouldn't. They're asking the department to do the decommissioning or otherwise say that they specifically do not have decommissioning responsibility, which the notice of violation actually does not have anything to do with decommissioning. It's just that they have
Well, the ALJ relied on that basically the decommissioning. I mean, there were two rationales that, and maybe this gets us back to the redressability point, which I do want to hear your thoughts about, but it seems to me that the requested declarations encompass both of the ALJ's applicability theories. One was that they control access, and the other one was that they decommissioned. Of course, they only decommissioned because you approved their plan to do so and didn't take possession of the RAM beforehand. But it seems like the declarations that they're requesting go directly to the two theories that the ALJ ultimately adopted.
Well, to the extent that Kensington did engage in any decommissioning, we don't assert that they were required to do so, but they started that decommissioning process even before
Well, they
closed.
tried to give it to you, and you said no, and we're not going to take it. And then they said, well, we'll clean it up. And you said, okay, we approve your plan. And then when they get to the end of the plan and they have to stop because some other government entity is suing them to make them stop, then you say, oh, well, you started decommissioning, so you've exercised possession of the personal property by doing that. I mean, that just seems like a total catch-22 to me. That's why people hate the government. When you get, two governments telling, I mean, what are they supposed to do, really, on the merits? What are they supposed to do?
Your Honor, these are valid questions, and I don't want to minimize the concerns that you have, but I do want to reorient the court to the fact that this is an applicability challenge under Section 2001.038, and that is a very limited waiver.
So
of
can I
sovereign
ask for
immunity.
clarification of your position on that? Did I hear you say that 038 waives immunity if they seek a declaration that this rule does not apply if they don't own, possess, or control the RAM? But it doesn't waive immunity if they seek a declaration that it does not apply because they don't own, possess, or control the RAM. Is that what you're saying? They could get this sort of broad, we want a declaration that this rule does not apply to someone who doesn't own, possess the property. If that's okay, it does waive immunity for that?
I think that's a closer call, the way that you have articulated it, if I'm understanding correctly. The first would be the broad factual situation which they're trying to seek just a declaration for. And the second one would be a little bit more specific to the facts of their case, because you have to determine whether or not first they possess or own.
Yeah, but see, that's what the second half of 038 requires them to do. They have to come in and say, we don't own or possess the property. Because if we do, then the declaration I'm seeking, then we're not threatened in any way by the enforcement of this rule. They have to come in, and to get under 038 at all, they've got to come in and show that they are threatened by the enforcement of this rule. So don't they have to come in and say it doesn't apply because we don't own or possess the property?
I'm not sure I agree with you, Your Honor. The third court does have case law that indicates that antecedent title or ownership questions are not part of a Section 2001.038
But they can
applicability
only
challenge.
get a declaratory judgment, quote, if it is alleged that the rule or its threatened application interferes with or impairs or threatens to interfere with or impair a legal right or privilege of the plaintiff. I mean, they have to, they can't just come in and say, hey, we want a declaration that this rule doesn't apply to anybody that doesn't own or possess the property. You're going to get out on that one for sure, because they haven't met the requirements of the waiver of showing that it affects them.
Right, and that's exactly what the BP case talks about, and I would point the court to that, where the court discusses how antecedent titleship or ownership questions just cannot be part of an applicability challenge.
Well, that was because
you lack
one of the
standing.
questions in BP was whether the state had title, and you can't sue the state to determine title unless you do it in a specific way with a trespass-to-try title action against an official and that sort of thing, but we don't have that here.
But
The
to-
question is, do they have title or does some other private person have title? So there's no way that that's out of bounds.
But to answer Justice Boyd's question, the BP case does go, it speaks to that to determine whether or not BP had a legal right or privilege. And as I understood your question, that's the nub of what you're trying to get to, whether or not they even have that legal right or privilege under 038A.
Yeah, I mean, I guess I'm saying that 038 does not, as I read it to include the second half, which requires them to show some impact on them. It doesn't waive immunity if they come in and say, we want a declaration that this rule doesn't apply if someone doesn't own or possess the property. It only waives immunity if they come in and say it doesn't apply because I don't own or possess the property. And you've got to get a resolution of that determination then to determine whether the rule applies.
And that's why the SOA proceedings are important. And so they were
But
able
they
to go
sued
through.
first.
I'm sorry?
They sued you first before the SOA proceedings. So how are the SOA proceedings even relevant?
So the SOA proceedings provide us a final agency action here.
Right,
And
but
of course
the point of this statute is that you don't have to go through the administrative process. So I looked into this statute, and it's part of the Model State Administrative Procedure Act. Nobody seems to talk about where this came from, but have you looked into how other states interpret this particular section? Because it's not just in Texas.
I've not looked at that.
It might be helpful if we have some
Okay.
briefing on that.
Well, I do understand that.
If I could, I'm hearing a distinction in your responses to Justice Boyd between a claim that under these circumstances, this rule does not apply to me, and a claim that under these circumstances, this party does not apply this rule does not apply to parties like me. And am I hearing you correctly that the latter might be permissible, but the former is not?
I think that's possible. Of course, I can't make that statement clear cut here at the lectern today because it just depends on the issues before the court in each specific case. What we have here is Kensington attempting to control state action, and that's exactly why sovereign immunity applies.
It strikes me as we should be careful about distinguishing between a claim that this doesn't apply to me and a claim that this doesn't apply to parties like me. It's a very fine distinction, but on top of that, just the way this is supposed to work is that you get relief from a court because that relief is available to parties like you. It's not that the courts aren't doing you a favor or making a legal judgment about you in particular. They're making a legal judgment about the class of persons who are like you and what are the rights of those people. And if you fall into that group, then these are or not your rights. So I'm struggling with the idea that we could put any weight on a distinction between the rights of this party and the rights of people like this party.
Well, again, I would point the court's attention to the LMV and the D. Houston cases. There, the declarations sought were detailed, just like Kensington's declaration here is detailed. It asks for specific relief that is specific to the parties involved. It attempts to control government action by specifying who the rule is supposed to apply to. Like in the D. Houston case, they're attempting to make this rule apply to someone else, just not them. I do think it's important to note also that Section 2001.038 does not confer jurisdiction to determine whether an agency has complied with a rule, and so we're looking at now past application, which is exactly what we have here. We do have that final agency action.
But again, this came first. So it seems like the whole point of this statute is to get around any sort of argument about exhaustion of administrative remedies, that you can have a pre-enforcement challenge. Otherwise, you wouldn't need this statute.
Well, what they could have done is stayed those administrative proceedings while they continued with their applicability challenge.
Why did they have to do that?
I'm not saying they had to do that. I'm saying that would have been one way to avoid a final agency action. And now, unfortunately, we have that final agency action.
Yeah, but it's going to go away if they win this case.
But that's not the posture that we're in right now.
It is the posture that we're in right now.
An applicability challenge is very specific. It goes to the applicability of a rule or validity of a rule. And so we can't look beyond the scope of that.
Well, if it doesn't apply to them, then the agency action is going to go away, I assume.
And that is why their judicial review case, which is currently pending in Travis County District Court, is the appropriate venue to resolve that kind of a question. Again, the court just simply does not have jurisdiction to resolve anything under Section 2001.038 here today.
Doesn't sound like we have jurisdiction to resolve much under that statute ever. You kind of agree with me.
Is that why the legislature bothered to amend 2001-038 to say that these issues can be sent to the 15th Court of Appeals? It seems like they think it has quite a bit of scope because they say the trial court can send these 2001-038 issues to the 15th Court, and then the 15th Court can have the trial court make any necessary evidentiary determinations in order for them to determine whether the applicability or validity challenge is good or not. So it seems like the legislature thinks this has quite a bit of force.
And perhaps it will under the 15th Court's jurisdiction. I think that's something that we'll all need to look forward to.
Well, the statute has to be broad enough for us to be able to do the same thing that the 15th Court can do.
Under the existing precedent and the relevant case law that this court can look to, I would say that these applicability challenges are relatively rare, successful. And I would say that in this case, Kensington just does not fall on the side of a proper applicability challenge.
Any other questions? Thank you, Ms. Jackson. Mr. Nord, you have 5 minutes.
Thank you. Again, if we look at the First Amendment petition that we filed, paragraphs 20 and 21, we have never at any point said or attempted to say or to prove that the state, that we can force the state to behave itself and do its job. The state is supposed to require licensees to have money set aside to clean up its mess. The state didn't do that. We do talk about it a little bit, but not as a remedy. We just talk about it because we think that the court should know that there is a remedy. There are people out there that have a job of doing this. It's
So
just not us.
you're not asking for a declaration that the state has to come and take this off your property, or that they need to go after the licensee?
No, Your Honor. So it's paragraph 20 and 21. They're not long. No accidental licensees and no categories of real property owners where radioactive materials is abandoned does not equate to a licensee.
So you're not trying to get them to do anything, you just want them to leave you alone?
It's just to leave us alone. That we are acting for no affirmative action by the state in this suit. No affirmative action. We leave us alone. That's all it is. It is funny to hear opposing counsel talk about, well, if we only want this to, it's about possession. But they never talk about what we do to possess. What they're saying is because we foreclosed on property and the personal property is on there, it's radioactive, we now possess.
Well, the ALJ said two things. One was that you possessed it because you decommissioned, but of course you did that because they approved your plan to do so and they wouldn't take it away when you asked them to do it. So what other option did you have? And then you stopped when the other entities, the government entities, told you, it sued you. But the other, I wanted to ask you about the other thing, because the other ground that the ALJ offered for possession was that you had control over access. And it seemed to me that maybe that wasn't actually correct either, because I saw somewhere in the record that you don't have a key, that the only person that has a key is the licensee that you hired to do the remediation or the decommissioning, and that you offered Dishes a key and they said they didn't want it, and then but that because you have this licensee in place, that somehow you're controlling access to it, and that amounts to possession.
I think that the question of control, it's a difficult one, right? Because we do have, it's sitting on our property. But there was a question earlier.
But you don't have a key. The only person that has a key is the person that's licensed by them, right? To do the decommissioning.
Yes, but the question is, if you evict somebody, you don't get all of their personal goods, right? If you foreclose on a piece of property, you don't get all the goods. If I wanted to keep the treasure chest, there would be somebody out there that would say, you don't own that chest, and this group of people would say, no, you don't.
Because it's not a fixture.
It's not a fixture. It's important. I like the Slay case. I'm going to move fast. The Slay case, which we cited, was a Superfund site. Person came in and bought the property. It already had all these issues. But the distinguishing, I like it because it's distinguishing in all the right ways. The materials that were damaged in containers were owned by the property owner. It came with it as fixtures and as containers part of the property. In this case, in our case, Denton County and all the taxing agencies, they have a different account for the personal property that's owned by USR. It's very different, very distinguished. It's also true that you can own property that has problems with TCEQ, and it's not illegal. It is illegal for us to move, to touch, to do anything with this property. So this is very much like a landlord evicting a tenant. You just don't get to say, oh, great, you've got a treasure chest in the garage, it's mine now. No, you don't get to do that. Even if you want to, you don't get to do that. So that is much more of the case. And I would again look at, if you compare and contrast the Third Court of Appeals statement about what we asked for to what we actually asked for, you'll find that no, we didn't ask for that. Another thing on the possession, whatever radioactive materials that we possessed under this theory that we decommissioned, it's gone. We don't possess that. We haven't moved, transferred, or contracted, or asked anybody to do that. So if that was true at any time, it's no longer true for what's remaining. There's not been any estoppel argument made today, or thus far, and people say, well, you started to do this and you stopped. Yes, but the state didn't change its position on this. The state didn't do anything. That has not been an argument, and I would hope that it doesn't arise today. As the court has recognized, we started and then their complications occurred, and we said we can't do this. This is kind of like, and this is my last metaphor or analogy, you foreclose on a strip mall, and you go to look at the strip mall, and then there's a semi food truck the size of a semi. I can't move it, I don't have a CDL. I can't operate the food truck, I don't have a license. Now, if I got into it, then it wouldn't be abandoned, it would be stolen because it doesn't belong to me. You can't just take things that are left on your property and decide they're yours. In this case, the state is trying to say this radioactive material was left on your property, and so now you have to be responsible for it. When it has several other people who have taken responsibility for it and should take responsibility for it. They have remedies, then they should use those.
Any other questions? Thank you, Mr. Nord.
Thank you.
Case is submitted, and the court will take another brief recess.